Commonwealth versus Fitzpatrick is a Pennsylvania case that very much reveals how that the principles we saw in the snippet from the Elliott case are very much a part of the Pennsylvania law, which is not terribly surprising. So in this case, what you saw was that there was really good evidence of a motive to kill, and that the method of killing was one that strongly indicated a state of mind that reflected the defendant's intended desire to kill. So in this case, as you know, the paramedics respond to to a situation along the bank of a river, and initially they don't suspect foul play. Mrs. Fitzpatrick is not conscious, but they're able to get a pulse. They take her to the hospital, and eventually she dies. Now, later then, someone reports that in the victim's daybook calendar, she's written, if something happens to me, Joe. And then they search her emails and find that she has written an email from her work email to her personal email and said that they were having marital problems, that there had been this strange accident where Joe had asked her to stand under some logs, and as they were trying to do something, and one of the logs came down and nearly killed her. She's afraid he's going to try to kill her. Then she ends up found dead found unconscious, and ultimately dies from some injury she suffers in the water. So they start to do a little bit of investigation. They now start to really dig in on this case. And what they discover is that the forensic pathologist doing an investigation of the body discovers that there are all these bruises. There are some 25 or so bruises on Mrs. Fitzpatrick's body. And the coroner now believes that the cause of death was drowning, and that the bruises on the body, and there are a number of them and they're very substantial, came from the victim's effort to get out from under the water as someone was holding her under the water, that caused her to die by drowning. So there you have a method of death that is quite consistent with an intent to kill. In fact, as the court noted, the Pennsylvania courts have previously held in a case before Fitzpatrick that death by strangulation is itself enough to conclude that the person desired the killing, because you have to actually think about it. You have to keep doing it. You have to apply force to suffocate a person, just like you have to apply force to hold someone under the water. So the method of killing, remember Elliott said you look at motive, you look at planning, and you look at method. And the method of killing, the Pennsylvania courts have had this particular method of killing is sufficient to show premeditation in and of itself. But as the court said in Elliott, we like it when we can find all three. We would prefer to find all three before we sustain a conviction for premeditated killing. Well, in Fitzpatrick, the court says we've got at least two of those, because not only do we have this method of killing that by itself is consistent with the desire to kill, because you have to keep doing it. You have to keep strangling, or in this case, you have to keep holding the person underwater. But in this case, there was a clear motive. The defendant, Mr. Fitzpatrick, was having what the court describes as a non-sexual affair with another woman. And he had sent texts to her, or he sent emails to her telling her how much he loved her. And then, perhaps most substantially, on the day of the murder, there are a number of texts that Mr. Fitzpatrick sends to his non-sexual affair partner, describing how much he cares for her, how much he loves her, and how that they may have plenty of money. She also, Mr. Fitzpatrick had also taken out a life insurance policy, or maybe they jointly took it, but there was a life insurance policy on Mrs. Fitzpatrick's life for $1.7 million. And Mr. Fitzpatrick, during the period, a few days before the killing, had Googled contestability of an insurance claim, and had Googled a search about the use of lie detectors in state courts. So there is plenty there to suggest that he desired the killing. The method of killing, this wasn't something that he just sort of came up with. At least during the course of it, he's willing to go through with it over a protracted period as she flails under the water. And then also, what was the motive for the killing? These texts and emails that suggest he will be with this other woman. So you have two of the three Elliot prongs that go to establish what's going on inside of his mind. The desire to kill his wife, that's there from both the way he kills her, his willingness to perpetrate this very long, protracted method of death. He has to really go through with it. It's not like he can quickly pull a trigger and be done with it. This is involved. There are plenty of opportunities to turn back in the middle of that. But then also there is definitely evidence to suggest, even before he begins that method of killing, that he has established a reason to want her out of the picture. So the trial court in this case had presided over a jury trial from which there had been a guilty plea, but the trial judge had then said there was insufficient evidence to show premeditation, intention, deliberation, and so had acquitted the defendant on the first degree part of the homicide conviction, reducing it then to some lesser form of homicide. But the Commonwealth appealed the reversal of the jury's verdict on first degree murder, and the Superior Court agreed with the Commonwealth that evidence of both motive and method of killing were sufficient to show that the defendant had intended to kill his wife and did so. And also, this shows how those three Elliott factors just very much are a part of the way the court went about making its decision in this case.